Told by Lucian that we only had an hour, so we're going to have to be very disciplined. We are looking forward to a conversation with all of you. We've just set one rule. Each of the speakers is going to speak for 5 minutes at most on one issue. If you want to make a comment, you just raise your hand. We have a microphone here, but you will be limited to a minute and a half, and this will ring if you go beyond, and you will be cut off. So my all-star panel here, I'm going to start with Mariana. Mariana heads the corporate integrity and competition law teams at Verano Advogados in Brazil. She represents local and foreign companies in investigations in areas of antitrust, anti-corruption, securities, and fraud issues. Mariana has represented companies in matters related to various enforcement actions in Brazil, such as Operation Car Wash, Operation Sipsis, Operation Greenfield, and Operation Zealots. They have the best names for criminal investigations in Brazil, obviously. Von Desk. Melody. Melody Wang is with Fangde Partners. She has handled some of the most high-profile and complex investigations in commercial disputes in China. In a bribery matter recently, she successfully convinced the Chinese investigative authority to let counsel take the lead in conducting a review and presenting the review findings to the authority, which was very much a breakthrough for China. She currently represents a multinational European company to handle a series of criminal investigations in China, which involved customs and environmental violations. On the commercial dispute front, 2 weeks ago, Melody successfully obtained a verdict from a court in Shanghai, which recognized and enforced a U.S. judgment. This is only the second case in history that recognized a U.S. Judgment by Chinese court. While the first judgment concerns 2 Chinese citizens living in California, this case involves 2 U.S. parties in a joint venture dispute and is widely believed to be a strong precedent for enforcing foreign judgments in China, and in particular, of course, U.S. judgments. And my third panelist to my right, the far right, is Wolfgang Spur from Hengeler in Frankfurt, obviously the German firm we all know. Wolfgang is a senior member of the firm's public law and regulatory group. He is involved in litigation before state agencies, administrative, constitutional, and criminal courts, as well as arbitral tribunals. He often advises companies with unusual legal challenges in high-tech sectors such as healthcare and telecommunications. Together with U.S. counsel, he's recently been advising European companies in industry-wide investigations by the DOJ, other U.S. regulators, and the German prosecutors, and that includes MLAT proceedings. Major recent cases include OFAC and DOJ sanctions investigation against a European financial institution, COMEX investigations representing Google Inc. in a high-profile antitrust and copyright law case. Wolfgang has defended cases of alleged criminal de facto employment of freelance on trial before criminal courts and federal Supreme Court in Germany. He is also involved in the diesel emission scandal for a corporate defendant. Last but not least, Kirby Ree from Miller Chevalier in D.C. His practice involves criminal investigations and prosecutions around the globe. He has extensive experience in global criminal cartel investigations and has experience which has resulted from significant exposure in Japan to Japanese clients and him handling those cartel issues. For the past 3 years, he has managed cross-border cases involving the UK, including the largest money laundering seizure in the history of the City of the London Police. From these experiences, he has gained an appreciation for differences and similarities around the globe in dealing with white-collar criminal issues, and he has seen the impediments that different enforcement regimes can place on cross-border cooperation. I am very grateful that they are all here today. We have discussed over the break not duplicating part of the panel you already had this morning, and with no further ado, we're going to address, of course, the privilege situation in various jurisdictions, and I'm going to ask Mariana to take the lead on her first comments.
Okay. So, hello. Well, it's a pleasure to be here. And I'm going to talk a little bit about privilege. I have 5 minutes to talk about this, so I'm trying to be try to be brief. the law is not very clear in Brazil with respect to privilege. In principle, it is actually very broad in its coverage. Both in-house counsel and outside counsel are protected. But this is what the law says, that any lawyer should have its communications, oral, written communications should be protected by privilege. However, there is some discussion on whether the level of protection for in-house counsel is similar or is as strong as the level for protection for outside counsel. So although the law does not make this distinction, there is some argument among some writers whether this would be similar. What is covered? Any communication with your client, written or oral. The law even protects places of work of lawyers and the legal departments of companies. In spite of this protection, it's not working. Here? Okay, thank you. So in spite of, much better. Thanks for bearing with me. In spite of this protection that is granted for the workplace of lawyers, we have seen in the recent past that many companies have had their law departments raided, which is obviously a problem. We also have seen that some law firms have also been raided. The situation with respect to legal departments of companies is that usually the lawyers, the in-house lawyers, they argue that there is privilege and therefore their documents should not be raided. But in a recent decision in the Lava Jato case, a decision that in one of the many raids that Odebrecht suffered, there are some documents were raided. They were collected by some in-house counsel, and they argued with the court that they should not have been raided. And the courts asked the officers to separate what involved their legal work and what did not involve their legal work, to try to ascertain what was privileged. The amount of documents was enormous, so the court officers could not do that. So the temporary solution, was to have all the documents sealed with the court, but everything was raided. With respect to law firms, we have seen that there have been some raids in law firms, but usually when the lawyer is suspected to have committed some type of illicit act. Even so, there's a regulation that states that in raids in law firms, it is necessary for a representative of the Bar Association to be present to assure that the rights of the lawyers are respected, and also to make sure that the only things that are raided are the ones that are specific for the purpose of the court order, and that documents relating to other clients or to other jobs of the lawyer are not raided. So yes, I think for this crowd here, it's important to know that with respect to the work involving internal investigation, these internal investigations are a recent phenomenon in Brazil. We have started doing this more like 5 years to now, so there's not a lot of tradition on that. And so we do not have court decisions involving whether or not the work made in internal investigations are protected. But in principle, yes, in principle they are protected. Although I have heard from some people saying that the work that is done in internal investigation is not actually legal work. So I think that one has to have more, be very careful with that. So what we advise to do is that in the context of an internal investigation, make very clear, I think someone said in the previous panel, be very clear in the engagement letter the purpose of the work that you're doing something in the context of an attorney-client relationship. And so this is something that a type of care that you should have. Foreign lawyers, I don't think that foreign lawyers are protected under a law, because although there is a protection foreseen in our federal constitution, which should apply to all, the main provisions that govern privilege, they are foreseen in the statute that governs the profession of lawyers. And this statute, it is directed to lawyers that are qualified in Brazil. So it's not that foreign lawyers are not covered, but if you're a foreign lawyer, if you want to actually assert a privilege, to be confident that you have it, you probably have to pass the bar in Brazil, which is not really hard. But you have to speak Portuguese, so it's a bit of a...
So thank you, Mariana, for advocating use of local counsel. I always like that a lot. So it's better to keep the documents at the law firm than in the corporate lawyer's office. Mm-hmm. And investigations, you should really draft rules at the outset to achieve the most protection possible. Yeah. Excellent. Thanks so much. So attorney-client privilege in China and conflict of interest. How do you manage that? I understand there's no privilege in China, right?
Yeah, right. Yeah. we don't really have economy class even in China in terms of that kind of protection. And also, I mean, this is my first time here for this conference, and I'm going to strictly follow Stefan's rules so that I get invited back the next year. Right. I think, I mean, it seems like our audience today are, you guys are all very sophisticated practitioners in this space, so that there's no need to really talk about the basic rules. But the general position under Chinese law is there is no such express rule for attorney-client privilege. Although there's some recent amendment to the criminal law which suggests that there might be an argument to make for defense counsel in the criminal investigation that the lawyer would have the right to keep whatever information they gather from the client confidential. But interestingly, the wording of the new provision seems to suggest that I mean, instead of what you would see under the U.S. position, that the privilege belongs to the client, but this Chinese amendment seems to suggest that the privilege belongs to the defense counsel. And that certainly creates an interesting dynamic between sort of, if you're in an investigation, between the client and the defense counsel. And also like how it's going to be applied in practice, it still remains to be seen. Some of our cases we've done, certainly we have tried to make that argument, and thankfully I think we haven't really had any real case in China that the authorities, either criminal or otherwise, that they have decided to raid a Chinese law firm or a foreign law firm yet. But certainly, in a high-profile investigation, especially I think the client should be notified and understand that there is no such protection. And for the case that I'm currently working on, so the client is a European company, and in the first place, we told them actually the overall strategy for this case, especially at this juncture, is gonna to have the authorities take the lead in this investigation. That would mean that perhaps what you would see in other jurisdictions, that once you have a full-blown investigation, the company would want to have counsel do some sort of internal review to basically understand what is going on and understand their risks and exposure. But here, given that there is no attorney-client privilege, there is always this risk associated with the company or the counsel doing too much ahead of the authorities, because there is a possibility that what you have done may end up doing the work for the investigators. So that becomes very, very frustrating for the client. And obviously we have to, in the practice, we have to have this get around sort of solutions that we will do some sort of interviews with witnesses and such, and to review the documents. But a lot of times we would avoid like taking extensive notes or sending emails that would be stored in our server in our office in China. A lot of communications would be face-to-face or over conference calls to discuss and sort of as the primary sort of channel of communication. So that is the challenge. And what's compounded the challenge here is also the conflict of interest situation. And a lot of times, like the case we're working on now, other than the company, also there are a number of employees are being arrested in custody as well. So what kind of arrangement needs to be put in place between the company's counsel and the employees' counsel, because they have to, at a certain level, they have to communicate with each other to understand their position and sort of like to hopefully find the common ground to operate, especially in the initial stage of the investigation. And because of the lack of the attorney-client privilege, that presents an inherent challenge in this sort of work. And also without that protection, we need to be careful as to how and how much detail we can communicate with the individual's counsel, given that there may not, in their interests between the company and the individuals, their interests may not always be aligned.
So that's very helpful. And again, thank you for advocating local counsel. This is actually, I think, the same problem we're getting again and again in jurisdictions where we're shifting to the US, UK style, or really US, and the UK has followed suit, where the clients are not used to this. And in a recent case, I was hired to do an investigation, and without telling me, the company had hired a French counsel whose role was to destroy everything I said, and said saying it was illegal. So now we're in front of the bar president on ethics. So it's interesting. You've heard a lot about Germany, but I'd be look forward to hearing Wolfgang's input on what we've already said, and also a few things he has to say about new legislation which may affect quite a bit the work we do in investigations.
Yes, thank you very much. When we decided on the topics of the panel, we weren't aware that is it working now? Yes. The privilege issue in Germany will be covered by the previous panel as well, so I can limit my I will make only a few additional remarks because I fully agree with the colleagues on the previous panel. The Federal Constitutional Court's decision is a bad judgment. It's poorly written, frankly, for a constitutional court. It's motivated by concerns or maybe prejudices that they do not spell out clearly, but if you read it, you sense it. But the only thing I would like to add is that the impact of this judgment will be much, much lower. So while I understand the concerns of the previous panelists, and it was very interesting to hear directly from the horse's mouth sort of an interpretation of how the case went, I think its impact will be extremely low. So I would like to make a few remarks to demystify the situation in Germany. The first element of demystification is that the same substantive rules apply for US and other non-EU law firms and German law firms. So the decision has no impact whatsoever on the level of criminal procedural law. So it's not, I mean, I'm partner of a major German law firm, but we don't use it as part of our advertisement materials. I can assure you. Because the decision about foreign companies is only about standing when you go to the Constitutional Court, and this is like a certiorari in the US Supreme Court. I mean, this is when everything else has been exhausted. It's not about the way criminal procedure law will be applied. And there, Björn's remarks about the diverging case law of the various district courts, I can't add much to that. Second remark, privilege is still protected in Germany. I think the overall degree of protection is pretty high. It's not too bad. And searches of law firms are only really done in exceptional circumstances. It's not always a Michael Cohen type situation where you also have had searches in the US, but it is usually an exceptional circumstance. It can be based on implications implicating the lawyer, the attorney, which has been the traditional strategy of German prosecutors. Say you've advised him, so you must have aided and abetted. And it can be extreme circumstances in this case. So I think, and overall, the advantage of German privilege rules is that there is no waiver doctrine, and much of what the German courts have been doing in this case is, there's also the Gibson-Dunn case involving the third German car manufacturer, would have been done in the US under the privilege waiver doctrine. So your federal circuit courts would have come to the same results. My theory is my personal theory. They would just have based it on waiver instead of on no protection in the first place. So some recommendations that, or some lessons learned. I think it's very important to agree on ground rules with public prosecutors in Germany early on. So this is very much the same that you do also in the US, is my observation with the Justice Department. There has to be a consistency of communication. If a company tells the public and the prosecutors we are fully cooperating, they can't send in people later who don't live up to that promise, and I think the US prosecutors wouldn't like that either. And the third important message is that you should not, in a case where the crime scene has been on German soil, and the diesel emission scandal, the crime scene has been to 98% on German soil, then you must not, under any circumstances, bypass the German prosecutors. Now, I know that this is not what the colleagues have been doing. It was probably more a strategic decision of the companies for good reasons they felt. So sometimes companies have strategic reasons. They say, you cooperate with the US, but look, French authorities, we don't tell them anything, and the Chinese, they're dangerous, capital punishment for corruption, don't tell them anything either.
Yeah, the problem is always the clients.
Yeah, and so this was the situation that I'm near, and I learned a fourth message out of the previous panel, and this was that the idea of splitting the roles of internal investigation and communication to the prosecutor is usually has very high risks, because then there is an elevated risk that the communication and the strategy gets inconsistent.
Great. Maybe just a couple of words on the new rules on disgorgement of profits and confiscation. If you just a sentence on that.
Yeah, interestingly enough, yes. In the first discussion, we heard how prosecutors are concerned very much about getting the profits back out of crime, and here we have new rules in Germany. We've had new rules for about a year now enacted, and they are very strict, and especially in the area of corporate crime, because they rely on what is called the gross principle. So although they speak of disgorgement of profits, it's not about profits, it's about turnover as a basis. And then there are certain exceptions that are pretty narrowly defined, and this gives prosecutors, if they use it, an extreme leverage, because in any, at least manufacturing company, turnover is much more obviously than profits. So the risk, if you fall under these rules, is very high for the individuals, because they don't have the money anymore. If it's all proceeds that they've ever received, not the profit, and for companies it's even higher. So the strategic, currently you can still solve it by accepting corporate fines against the company, because in the administrative sanctions law it's still only profit and not turnover or gross proceeds.
Thanks so much. Kirby, on the issue of, we've seen how different jurisdictions can approach same issues very, very differently, and maybe a few words in your experience on how different approaches to legal issues have impacted cross-border investigations.
Sure, happy to do that. This morning we heard from the regulator roundtable the goal, at least, of countries, in this case US and UK, to work, I think the term that Lisa used was in perfect harmony. And I think that's an aspirational goal, and in many cases it's worked. But like a good criminal defense lawyer, I'm not going to focus on the perfect harmony that the government creates. I'm going to focus on the disharmony that occurs when they don't coordinate all that well. The example I'd like to share with you involves Japan. Many of you might be familiar with the global investigation of the auto parts industry that was almost exclusively focused on Japanese companies. And as a result of two things, I think, the coordination and cooperation between Japan and the U.S. was not optimal. And that disagreement stemmed first from a disagreement over how serious a crime anti-competitive conduct is. So I think that the U.S. treats it very harshly, and in Japan maybe less so. But even more important than the substantive area of law at issue was the fact that the U.S. government was investigating extraterritorial conduct that occurred almost exclusively in Japan. So as a result of those fundamental differences, that disharmony, what's resulted is that in many instances, the Japanese government did not cooperate with the U.S. And here's what's happening. Could you put up that slide? Sure. Just hit the arrow. So we have the good fortune of an investigation that lasts 6 or 7 years, and it's actually, this chart ends in 16. There's actually some couple of examples in 17 and early 18. But this depicts very, starkly the impact of what happened in this case in terms of Japan refused to extradite cartel defendants to the U.S. to be prosecuted. So you see early on in the investigation in 2011, 2012, there were a total of 12 different defendants. And each one of those agreed to fly to the U.S. These are all Japanese nationals. Fly to the U.S., submit to the jurisdiction, plead guilty, and do jail time. Now that's remarkable because I think in almost all of these examples, many had not even been to the U.S. before. And yet, through their U.S. lawyers, they agreed to plead guilty. But eventually, after these first couple of years, it became clear that the Japanese were not happy, the Japanese government was not happy with the fact that the U.S. government was pulling these people out of Japan and forcing them to come to the U.S. and go to U.S. jail. So eventually, the thinking changed, and you can see in 2013, whereas before the first 2 years, it's 100%, these first 12 people all submitted to the jurisdiction and they all pled guilty, and they did their jail time. But by 2013, the conventional wisdom shifts dramatically, and you have, 60% versus 40% saying, I'll plea, but that 40% said, no, you go ahead and indict me, you can charge me, but I'm not coming to the U.S. And as time goes on, if you look at the chart, you'll see that eventually, by 2016, virtually all defendants said, thank you, but no thank you, you go ahead and indict me. And the reason they made that call was because it became clear 5 years, 6 years later, that the U.S. government was perhaps not even going to ask to extradite these individuals. And it was also clear, and this is anecdotal and through Japanese lawyers, but it was also clear to the Japanese lawyers that Japan would never extradite. And it was also clear to the Japanese lawyers that the U.S. would not even ask for extradition because of the fact they knew it would be denied. So you have this situation where the situation flip-flops, and it goes from complete submission to the U.S. jurisdiction and complete submission to this extraterritorial reach by the U.S. into another country to where thanks to the other country, these defendants almost exclusively said, no, we're not going to do it. So countries can, as the saying was this morning, countries can live in perfect harmony, but when they don't live in perfect harmony, they can directly and dramatically affect a criminal investigation by another country, here the U.S., but it could be in other countries as well.
Thanks so much. So when we talk about conflicting views on investigations and policy, maybe Wolfgang, in just a few minutes, recent corporate trends, corporate enforcement trends in cross-border cases, and from a German perspective.
And this is really something also for discussion, because I'm sure many in this audience will have experience in those cases. I mean, while in theory Germany has no corporate criminal law, the practice is that German public prosecutors are investigating allegations of corporate wrongdoing vigorously, and they are also prepared to try untested or unconfirmed legal theories when they prosecute corporate wrongdoings. And one example of this is the withholding tax, share withholding tax double dip that was considered legal in Germany and in the legal community, in the tax community, by many people and many lawyers. They are now investigating that as part of organized tax fraud. Also investigating, and also they have searched some UK law firms and German law firms, and so it's not just that US law firms are getting the hit, I can assure you. And here also they, by the way, are using electronic surveillance and telephone tapping also of lawyers, but the specific situation is that the attorneys were not defense attorneys. They were historically advising to do these transactions and were promoting them. Then you have the diesel emissions cases where, as most of you will probably know, there are no direct sanctions, unlike in US law, for violation of car homologation rules in Germany. So it's not even a petty crime. It's no crime, or there is no violation. So now they are prosecuting it under theories of consumer fraud as a sort of substitute for... And also prosecutors are taking a very specific international perspective. They are also prosecuting the US fraud in the Dieselgate cases. So they do not limit their prosecution to the European sales of cars, also because they think it will be easier to prove, because they think they have an admission by one of the companies. And in the Cum-Ex cases, the crime scene was mainly abroad, because the tax law loophole had been closed in 2009 for domestic players. So only foreign players in London, in the US and elsewhere, were able to get this withholding tax. And there are three peculiar features of German criminal law in a comparative perspective that makes it very broad. You have a very broad concept of criminal aiding and abetting. And this is especially useful to name lawyers as a suspect if you want to search their premises under traditional pre-Volkswagen rules. There is a very broad concept of intent that is, in my observation, much broader than the concept of intentional wrongdoing, for example, in the United States. And then you have a very broad concept of senior management responsibility under concepts that were developed for historical crimes of the German dictatorships, where you also had the problem that the guy who pulled the trigger at the German border was not the really responsible person. That was someone much higher up in the hierarchy, and the German courts have adopted that theory for wrongdoing in big organizations like dictatorships and states. They were sort of are now using that as a theory to establish the responsibility of senior management.
Maybe one question, Wolfgang. How do you, so we understand that they just take a huge view on who can commit the company, including apparently a clerical employee. How can you shield your clients from that? I mean, how you know, if you have a sub of a large foreign company, how do you try and protect your company from that sort of what sounds outrageous, involvement of the prosecution?
Once wrongdoing has occurred, or before?
How can you prevent? So it's just sort of ahead of time, if at all possible.
Once it has occurred, I think the trend will be in Germany, like in the US, if there is serious wrongdoing that's not very minor and not subject to German jurisdiction, the only way will be cooperation. I think the traditional way of defending a company saying, look, we don't think there's anything behind it, that's ridiculous, we don't do anything, we not cooperate, you have to prove your crime, that will be gone.
Okay, that's sort of a general trend. And what about? Thanks so much. What about Brazil? What's the perspective on international cooperation in Brazil?
In Brazil, we have there's a greater interest by the enforcement authorities in the international cooperation. The car wash operation, one of the key aspects of the car wash operation was and is international cooperation. So, and the prosecutors, they always say that the two most relevant aspects that allowed car wash to have some success was the plea bargaining agreements, which was something that did not exist before, was not regulated before 2013, and international cooperation. The first cooperation in the Lava Jato case occurred in August 2014 to Swiss authorities. The Brazilian authorities wanted to find banking information about that could confirm allegations of a person who had pled guilty. And since then, there have been according to official sources of the Brazilian Public Prosecutor's Office, there have been over 500 requests for cooperation. So since 2014 to 2018, 500 requests. 250 more or less made by Brazil to other countries, and the rest made by other countries to Brazil. And over 55 countries involved in these requests. So I think that also a relevant point is that because of the repatriation, because of the car wash operation, we could see that there was repatriation of some funds to Brazil, and also according to official data of the enforcement authorities, this is based in September from 2004 and 2014, which is before the car wash. The total amount of money that was repatriated corresponded to 45 million reais. So the reais, you have $1, now it's 4 reais, so it's very low for 10 years. And then since 2014 until August 2018, after the car wash, they managed to repatriate 2.5 billion reais. So it's very impressive in that sense. I think just one last point on the international cooperation. There was I think that when I say that the enforcement authorities are more interested in international cooperation, it's because they are really involved in other investigations that may have an international dimension. In May this year, there was the start of a new investigation, which involves we call it a câmbio de desligo operation. It's a foreign currency case. Basically, there was a parallel system of foreign exchange that was led by a few individuals, and there was a simultaneous raid in Brazil, Uruguay, and Paraguay, and apparently 60 people were arrested, I think at least temporarily, and they were all black market dealers. So this involves a coordinated effort by these authorities. And if you think that the car wash operation initiated because one black market dealer was arrested, now we had 60. So we have, I think the perspective is that this is going to be a big one too.
Thanks so much, Marina. Maybe just one short question. We've all saw that the presidential election gave a Trump-esque result. Mm-hmm. Do you think that's going to impact? I mean, I understand that the quid pro quo is really what led the prosecutors in Brazil to want to help out. Now, do you think this could? I mean, it's maybe too early to say, but do you think that could impact?
We have. It's not over yet. We have, yesterday were our elections, and we have we have a second round. And one of the candidates who is very popular, he's very authoritarian, and it's very unpredictable.
Okay. Yeah,
It's
it
very
was a tough question.
unpredictable. It's not impossible that the law is going to change,
Right.
and more abuses are going to be
Sort of a
made.
more patriotic approach to enforcement.
No.
Cool. Thank you. Thank you so much. So with all these authorities cooperating with one another, might as well sort of, join the dance and try and get some credit for that. So how do you get credit for cooperation in China?
Yeah, so in terms of the international cooperation, I think it's probably less common in China than what you would see in other jurisdictions. And I think the reason might be twofold. One is the general lack of resource of the Chinese authorities, and that probably is true for a lot of countries. But the second reason, I think it's probably the primary reason, and that would be unlike in the U.S. Or UK to a certain extent, that there is sort of a centralized enforcement agency like the SEC or DOJ that would enforce the law. But in China, it's very spread out in the sense that we have the central level agency, but every agency would have its local offices that would be tasked with and would have jurisdiction over any enforcement action in its own locality. So in that sense, in terms of a sort of enforcement action, it becomes very much of a local office's concern or consideration on whether they want to sort of start this international cooperation, or whether they want to tag along. Let's say there's a U.S. FCPA investigation that involves the facts and findings involves China, and whether they want to initiate something in parallel or after the fact. And there have been a number of China-related, I think, at least FCPA investigations that have been either settled or decided by the U.S. authorities, but we haven't really seen the Chinese authorities initiating the same sort of action, and that certainly presents a challenge in terms of companies, especially multinational companies, when they think about how they're going to get cooperation and credit. Let's say, for example, in the U.S., that if they do a voluntary disclosure or they settle with the government, and what kind of risk or exposure is going to bring to the China sort of investigation or China actions, and vice versa. And what's more challenging in China is that unlike in other jurisdictions that we heard earlier this morning, there seems to be a more clear guidelines in other jurisdictions as to how you can get cooperation credit. But in China, that it's very uncertain as to like how it's going to impact the outcome of the investigation. And certainly in a lot of cases, especially those high-profile cases, in theory, multiple agencies would have the jurisdiction over one case. So if you have settled or get the cooperation credit with one agency, whether that's going to apply, the other agency is going to apply the same sort of method, or whether they can start something completely separate in parallel, that's a big question. So I think a lot of clients, actually, whenever they have a China-related problem in other jurisdictions, they will come to us and ask, shall we make a voluntary disclosure or try to get some cooperation credit with the authorities? And most of the time, honestly, our answer would be probably no, because of the lack of the clear guidelines, like what kind of lenient treatment you're going to get. And there is this very inconsistent practices among the different regions of China. A couple of years ago, we have a very big pharmaceutical company that's under investigation in China. And basically, the 5 different regions that we call it provinces, the provinces that the authorities are initiating and participating in the same investigation. So how you can manage, to get sort of the same sort of lenient treatment with each different location, it's certainly very much a challenge to navigate and manage in that process. So long and short of it, I think it's the international cooperation, and as well as, to try to get the cooperation credit from the local agency is quite, I think it's less common in China compared to other jurisdictions.
Excellent. And again, local counsel is very helpful.
Sure, right.
So, on occasions, authorities don't cooperate, and when they don't, then you're in a very difficult position. And Kirby, maybe a few tips of the trade.
Yeah, my second example of the harmony versus disharmony is probably closer to harmony than not. It's certainly not the Japanese example in auto parts, but this involves SBM, the Dutch company that was investigated for FCPA-like violations back in 2014. And that area of law, unlike criminal cartel law, is one that the U.S. has, shall I say, exported to other countries. And as I understand it, the U.S. Department of Justice has trained prosecutors around the globe, including in the Netherlands, about how to prosecute, root out, and coordinate on anti-competitive conduct. So this case involved SBM, a Dutch company, and this was their maiden voyage into these types of investigations and prosecutions. And as it turned out, the Department of Justice wholeheartedly agreed to let the Netherlands take the lead, and in fact, the U.S. investigation was closed so the Netherlands could have their first case and establish themselves as a leader in this area. And that resulted in a fine of about $240 million. So in one sense, the system worked. The countries played nice, and we deferred, the U.S. deferred to another country. But eventually that investigation was reopened, and it's a bit of a dispute as to whether it's reopened based on new evidence, pre-existing evidence, the function of new information. But the U.S. investigation was reopened, and Brazil opened an investigation. So SBM thought they might have bought closure and not suffer piling on by settling for the 240 with the Netherlands. Long story short, the U.S. government ended up extracting a fine of $238 million. You might ask, why is it so close? Well, I think it was a kind gesture on the part of the U.S. to suggest to the Dutch that they're going to get more than the U.S., but only $2 million less. And so all of a sudden, then they were up to whatever that is, 480 million. Brazil, last but not least, came to the party last. And as I understand it, Mariana, it's probably, 75 million or so now? Is that what it totals?
Yeah.
And is it over?
I don't think so.
Yeah, so that's still going on. So, the company thought it was buying global peace, and I'm exaggerating to make the point, when it settled with its country. And again, new information, maybe all bets are off. But at the end of the day, they ended up paying a multiple of what they thought they were going to pay. And so the question becomes, impossible to measure, is this piling on? Did they end up paying grand total 550, 600 million, whatever it was? Did they end up paying more because this was chopped up among countries? Or did they pay did the pie get any bigger, or did it stay the same? And it's impossible to know, but it appears that maybe the pie did get bigger. So there was coordination. I think the U.S. government points to its training of the Netherlands as something to be proud of, and they deferred to the Netherlands. But at the end of the day, did this company suffer kind of a tax, if you will, from this kind of one after another effort to prosecute him?
We'll never know. No. Mariana, just a few words maybe on the settlements with legal entities from a sort of Brazilian perspective. And then, Melody, you better be ready, because Lucian is just looking at me, and we're close to the time.
Yeah, sure.
Okay.
Smiling
Yes.
He is smiling, but
About the settlement in Brazil, as I said before, the plea bargaining agreements, they are sort of new because they were only created and formalized, regulated in 2013. And there's not really a culture of cooperation in Brazil. a culture of pleading guilty, a culture of confessing your crimes to the authority. But this is something that is now huge. Since the car wash, the plea bargaining agreements, there have been around 176 only in Curitiba, which is the place where most of the action is going regarding Lava Jato. But there's a problem today for companies who want to settle, because companies, they are not criminally liable in Brazil, but they can be prosecuted based on civil law and based on administrative law, and they may be subject to fines, to debarment, and also to damages. So there's the problem, the challenges that companies face today if they want to settle in Brazil is because there's not a very organized structure for incentive. You have different authorities that can prosecute the company based on different legislation, and there is some overlap among the legislation and the jurisdiction of these authorities. So it's very difficult, even within Brazil, to go to one authority and make a settlement and get it over with. You have to really make a big effort and try to. What most companies are doing is that they are going to two or more authorities to make the settlement. It's very difficult to have one single settlement that involves all. Just as an example, I mean, the famous Odebrecht case, when Odebrecht settled with the public prosecutors in Brazil, which was in December 2016, it also settled with the DOJ and the Swiss authorities at the same time. It only settled with the federal prosecutors. It did not settle with the administrative authorities that could also prosecute Odebrecht and ask it to pay fines and have it debarred. They only settled with the administrative authorities now in August 2018. And they also had to pay a fine. I don't know the amount of the fine, but they have been trying for 1.5 years to have this settled with these authorities too. And a similar situation happened with SBM. They actually first attempted to settle in Brazil with all the authorities in July 2016. It was not approved by a chamber of the federal prosecutors, and they were only able to settle the first case in July 2018 with the administrative authorities, and only now in September 2018 they settled with the federal prosecutors. So they did. If you see Odebrecht and SBN, they sort of did. They had different approach. Odebrecht started with the federal prosecutors and then went to the administrative authorities, and SBN did the other way around. When I say that it's not over yet, it's because after the settlement, they have to keep complying with all the, the obligations that they undertook. So it's a hard thing still in Brazil for companies to settle. Not very good news for companies.
That's actually very scary. I was complaining about French authorities being disorganized, but when I hear this from China and Brazil, I mean, we sort of have a very good domestic double jeopardy.
Everything is relative, right?
Exactly. We have a good double jeopardy defense in France because all of these behaviors would be considered criminal. And despite being sanctioned by an administrative body, you would call it criminal, although it doesn't always work. Melody, the U.S. had a pilot program. China has one now. Did you copy the U.S.?
Probably the attempt was to copy or borrow some sort of the concept, but in effect, I think it's still it doesn't really work as we had hoped. There was recently this pilot program was introduced about a year ago in China, sort of like a plea bargain with the prosecutors. And it seems like the scope of application is rather limited to more minor offenses, and it doesn't really seem to apply to many of the sort of the corporate companies that we would be concerned about. And there is just no such concept or culture that would have the prosecutors that would agree to arrangement with the companies to sort of a plea bargain arrangement officially. But our past experience suggests that there might be some creative ways of sort of entering into a negotiation with the prosecutors, in particular, before sort of they push forward the indictment for the company, that you can sort of negotiate, especially for a multinational company. And a lot of the local prosecutors will be concerned about sort of the international outlook and the optics of such a case, so that they would be more willing to have a negotiation with counsel on some arrangement as to like what is sort of the acceptable charges that would be for the company and what would be their recommended charge to the court. But it has to be very carefully structured and crafted, in the sense that because of that there's no such formal kind of arrangement under the law, whatever arrangement you've made or agreed with the prosecutors, it's not official. So whatever admission or compromise you have made may become ultimately that admission later be used against you in the court. And it may, if no arrangement or no agreement can be reached with the prosecutors, it may later on become sort of what you have compromised on become the baseline for their recommended charges, and it could go higher up ultimately with the court. So whatever sort of negotiation you want to have with the prosecutor, it has to be very, very carefully structured.
Thanks so much, Melody. We do want to open it to questions or comments from the audience, if anyone has anything to add. Okay, well, no.
Well,
maybe just a word on the new supervisory committee.
Yeah, right. I'm going to be very quick on that, because I know that Stefan has a stick under the desk. Yeah, that's a new authority that's just formed in China. It's a consolidated authority that's tasked with prosecuting bribery or corruption-related charges. And what's unique about it is it's not really only a judicial body, but it also is a sort of a Communist Party organ as well. And what it does is it can, other than, in addition to what's under the criminal law, that they can press charges and do investigation, but they can also investigate or punish Communist Party officials for violation of the party rules. And what's relevant to us is a lot of the multinational companies would be considered as the party, or not the target, but the party who has the necessary or relevant information related to their Communist Party investigation. And we've come across a couple of cases that our clients would be summoned to provide information or to be subject to interviews by this kind of organization. And that has to be done, again, it can't really be taken lightly, because whenever they find any wrongdoing, that they would have the power to either investigate the facts, or they can transfer the case to another like regular prosecutor to investigate on the private targets.
And this body sounds very scary to me.
Whenever there's the word communist,
maybe I'm too American for a Frenchman. But do they have any specific way of doing things? Do you still have counsel? How does that?
Yeah, I think for in terms of the officials that's being investigated, that they have everything that's available, would be possible, that under the sun, that they can use. And for sort of the private party that's involved, under the law, basically it says, like, whenever the authority is collecting the information, it didn't really expressly give you a right to hire counsel. So before you are officially a target of the investigation, the authority may or may not deny you the right to hire counsel. He said you don't really have that express right.
Okay, scary. If there's no questions from the audience, maybe just a roundup comment. Wolfgang, Mariana? Oh, we're going to be early.
Well,
Yes, please, go ahead.
In order. I think what's very important when we have the fact that corporate wrongdoing is global, and we see increasing cooperation among authorities and also among lawyers. Of course, we definitely need principles for international double jeopardy to be developed, and here within Europe, you have the ECJ and the European Courts of Human Rights that might create something, but it would be really great from a European perspective if this no piling on idea from the Department of Justice would also be extended to international coordination, and of not just of procedures but also of outcomes and sanctions.
Great. Mariana, do you want to add something?
Yes, just a final word here. I think that in Brazil, we are, I think that what would be very good would be for the Brazilian authorities to coordinate among themselves. I think that now there is some kind of effort to make the lives of the lawyers and the companies a bit more predictable. And I think for the foreign crowd here, I would suggest that you continue following what's going on there, because I think there's going to be, I hope there's going to be improvement in laws and in the terms of how the authorities coordinate. And I think this may be relevant for your clients.
Adi?
Yeah, I like Stefan's recap always, and saying, emphasizing the importance of local counsel. So yeah, just a final word. I think, I mean, in terms of Chinese lawyers, I mean, we think we are lucky to live in an interesting time. Certainly, that the Chinese authorities are more aggressive than ever in enforcing the law, and given sort of the differences in the system as well as culture, it certainly presents a lot of challenges. But I remain cautiously optimistic as to sort of it seems like the system would be more and more open, and probably would be more sort of adapt to the sort of the international practices and standard.
Excellent. Kabir?
Briefly, my third and final example of harmony, disharmony among and between countries is the EU data privacy laws, which as a non-EU lawyer I find baffling and unintelligible. And I'm glad to hear that the EU lawyers tell me that there really is no easy workaround, because that's what I'm looking to find out, and it doesn't seem like there is. But as more and more countries include cooperation agreements in their dealings with foreign companies, those data protection privacy laws become more and more problematic. And by that I mean they impede the ability to get information that frankly governments like the US want. And it's not just the information itself, but it's the documents, the emails, and the data behind it. And in one sense, I understand why the EU is imposing these privacy protections. On the other hand, it clearly, if it doesn't prohibit the exchange of information, it does slow it down, and it makes potentially the quality of the internal investigation that is fed to the government suffer. And I don't know I don't know that there's a way to reconcile it, but there's definitely a tension in that area.
Thanks so much to all four of you, and one time.